Hi everyone, this is Targaji Chaudhary on behalf of Law Mantra, presenting the recent judgment of Supreme Court. Today here I am going to discuss about the recent judgment of Supreme Court on constitutionality of Section 19 subclause 11 of Tamil Nadu VAT Act 2006. The statutory scheme delineated by Section 19 subclause 11 neither can be said to be arbitrary nor can be said to violate the right granted to the dealer under Article 19(1) subclause G of the Constitution. The Supreme Court on Friday dismissed appeals filed against Madras High Court judgment that had upheld the constitutionality of Section 19 subclause 11 of the Tamil Nadu Value-Added Tax Act 2006. The bench, comprising Justice A.K. Sikri and Justice Ashok Bhushan in ALD Automotive Private Limited versus the Commercial Tax Officer, held that statutory scheme delineated by Section 19 subclause 11 can neither be said to be arbitrary nor can be said to violate the right granted to the dealer under Article 19 subclause 1 subclause G of the Constitution. The bench also held that time period as provided in Section 19 subclause 11 is mandatory and there is no power conferred on any authority under the Act to dilute the mandatory requirement. The law under challenge. Section 19 subclause 11. In case any registered dealer fails to claim input tax credit in respect of any transaction of taxable purchase in any month, he shall make the claim before the end of the financial year or before 90 days from the date of purchase, whichever is later. The issues. The issues considered by the Apex Court bench were the following: whether Section 19 subclause 11 violates Article 14 and 19 subclause 1G of the Constitution of India, whether Section 19 subclause 11 is inconsistent with Section 3 subclause 3 of the Act, whether Section 19 subclause 11 is directory provision, non-compliance of which cannot be ground for denial of input tax credit to the appellants, whether denial of input tax credit to the appellant is contrary to the scheme of VAT Act 2006, whether assessing authorities could have extended the period for claiming input tax credit beyond the period as provided in Section 19 subclause 11 of Tamil Nadu VAT Act 2006. Constitutional validity. The bench mainly referred to decision in Jayam and Company versus Assistant Commissioner and another, and observed the constitutional validity of Section 19 subclause 20 was upheld. The above decision is a clear authority with proposition that input tax credit is admissible only as per conditions enumerated under Section 19 of the Tamil Nadu Value-Added Tax Act 2016. The interpretation put by this court on Section 3 subclause 2 and Section 3 subclause 3 and Section 19 subclause 2 is fully attracted while considering the same provision of Section 3 subclause 2 and Section 3 subclause 3 and provision of Section 19 subclause 11 of the Act. The statutory scheme delineated by Section 19 subclause 11 neither can be said to be arbitrary nor can be said to violate the right granted to the dealer under Article 19 subclause 1G of the Constitution. Mandatory provision. The bench, answering the third and fourth issue, observed that if the provision is held to be directory, it will become too flexible and give rise to a large number of difficulties, including difficulty in verification of claim of input credit. The bench observed Section 19 subclause 11 thus allowed an extended period for input credit which if not claimed in any month, can be claimed before the end of financial year or before the 90 days of the date of purchase, whichever is later. The provision of Section 19 subclause 11 is thus an additional benefit given to dealer for claiming input credit in extended period. The use of word shall make the claim needs to other interpretation. Authorities can't dilute mandatory requirement. Answering the last issue, the bench said that in the scheme of Tamil Nadu Value-Added Tax Act 2006, there is no power conferred on any authority under the Act to dilute the mandatory requirements under Section 19 subclause 11. The taxing statute has to be strictly construed. Nothing is to be read in, nothing is to be implied, and language used in taxing statute had to be looked into fairly. The benefits envisaged in the taxing statute had to be extended as per the restrictions and conditions envisaged therein. The statute having not given any indication for extension of time, which is a condition for claiming input tax credit, the submission that period could have been extended by assessing authority is unfounded and cannot be accepted. This much for today, and please don't forget to subscribe our channel Law Mantra for more legal updates. Thank you.